Hi there, it's Kathy Missildine, and we are going to discuss the U.S. laws and regulations this week. I think it's important to hit some of the highlights on these laws because some of them can be very confusing, and I think the materials are well laid out and offer a lot of good content. Also, on the learnhrm.com site where you go take your quizzes, there is in the resource area there's a listing of all the laws. You can print that out, and that really makes a good study guide as well. The main thing to think about with these laws is thinking about the context. What was going on in that period of time that necessitated the need for this law? Title VII is an easy example. We had racial unrest, the Vietnam War, women coming into the workplace. So it was a time for kind of regulating fairness, if you will. And so just think about it like that, and I think it'll help you understand and remember the reason for the law, thus understanding what the law is supposed to do. So that's my 2 cents on that. So what I'm doing is I'm looking at the PowerPoint presentation, which is another good resource. I think it does a really good job of hitting the highlights of this section. And so I'll be going through this to hit the highlights on probably Title VII, including sexual harassment. The ADA is another big one that we need to talk about, including reasonable accommodation. Of course, the FSLA, the Fair Standards Labor Act, that covers many things: overtime, exempt, non-exempt, contract labor, things of that nature. That one's a pretty big one, and that one's applied to almost everything that we do within HR as far as compensation is concerned. So we'll talk about that, FMLA, and any other little tidbits that are woven in through here. So the intent is to make you feel comfortable with the laws and giving you enough content and knowledge and explanation so that you can discern when your antenna should be up in regards to employee relations in your workplace, but also obviously we want to make sure that when you're in the testing environment, you can recognize when one of these laws comes into play. Okay, so let me get serious by putting my glasses on. So let's start off with talking about what's meant by when we're talking about equal employment opportunity. Let's start there. We use this terminology in the recruiting process and the selection process a lot. We are an EEO employer. And what does that mean? Well, basically, it says that we do not discriminate against different classes of individuals, and those being of race, sex, ethnicity, religion, age, color, veteran status, genetic information, FMLA entitlement, and disability status. And so those are the areas, and there are 10 of them. Some of these are found in Title VII, GINA, FMLA, many pieces of legislation, but those are the 10 big ones that we have to be aware of. And so when you're thinking about discrimination at the bottom of slide 14, sorry, that was on slide 13, you want to kind of discern what type of discrimination is. So we have disparate treatment. That means you're treating people differently, and it goes to intent. To treat somebody differently, there's some intent behind that. You're treating Sally different than you're treating Ed, right? Or you have disparate treatment, or disparate impact, or adverse impact, as some people call it. It's when a neutral policy has a discriminatory effect. You didn't mean for it to when you wrote that policy, but for some reason it has a disparate impact on a protected group. So let me think of an example. Perhaps we have a written test, and it's for entry-level positions, maybe high school graduates, but the language is such that it has a disparate impact on females or a racial class. So it's by being that way, it's self-selecting a whole demographic of individuals because of the nature of the language in the test. Now, did we do that intentionally? No, but we probably didn't test it to see if it had that impact. So just keeping those two clear in your mind, the difference between the two. So then the PowerPoints get into Title VII. So let's talk about that starting on slide 17. Title VII covers 5 of the 10. So it's race, color, religion, sex, and national origin. So I'd like to draw your attention to the term color in here because a lot of individuals are not sure the difference between race and color. So if we're thinking about our races in particular, Hispanic and African American, there could be variations in skin color, and sometimes there is discrimination within races or different races regarding skin color. You could be a light-skinned African American or a dark-skinned African American, so that's the difference there. So the slide 16 goes into the definitions, terminology used in Title VII. I would review those to make sure you're very clear on that. And then understanding what exactly does Title VII mean. And slide 18 does a great job of that. It makes it unlawful to discriminate against any individual based on the 5 things: race, color, religion, sex, national origin, to all terms of employment. Most people make the mistake and think it's only hiring, recruiting, selection, things of that nature, but it's compensation, it's training, who has access to training, promotions. Thinking about the entire employment cycle, we are not going to discriminate in any form, fashion throughout the cycle. Also, it does protect against harassment and hostile work environment. So those appear later on in the slides, but I do want to go ahead and talk about that for a moment since it's here on slide 18. Because we have gender as one of the 5, male, female, that's where harassment came in. Now we know it can be same gender as well. So 2 forms of sexual harassment. One is quid pro quo, this for that. If you do this for me, and it's maybe of a sexual nature, I'll do this for you, promotion, raise, etc. Then those are not as common as hostile work environment, but they still occur. Very hard to investigate because it's typically one person's word against the other, usually not done in a room full of witnesses. So it's tough to investigate and tough to get to the kind of truth of the matter. Hostile work environment, on the other hand, is more common. That's where the environment that you're working in makes it difficult to perform your job because it makes a hostile environment. In other words, environment that may have racial jokes being spoken or sent over email, offensive pictures or offensive religious symbols in the workplace, yelling, screaming, offensive language, use of profanity in the workplace, so things like that. So basically, it's, what would a reasonable person consider offensive? And that's difficult because some people are sensitive and others have high tolerance for things like that. But let's keep in mind what the goal is at work. Really, it is to get our jobs done in a productive way, in a healthy environment. So we need to be able to provide that for our employees. So just remembering that harassment, hostile work environment do fall under Title VII. Now, with any laws and rules, there's several exceptions, and there's 4 exceptions to Title VII, and I definitely would know and understand these. In my experience, they like questions around these exceptions. Work-related requirements. So thinking about a fireman, they have to lift heavy things. So maybe their requirement might be able to lift 75 to 100 pounds. Not too many women can do that. Not all, but not too many can lift up that much weight. So that might have a disparate impact on women, but the reason is because the job requires you to lift that much weight. The next one's a BFOQ, bona fide occupational qualification. There was a case regarding this not too long ago involving Hooters. We're all aware of Hooters and their brand. A male did apply for a job as one of the Hooters girls, believe it or not. He felt he was discriminated against when he did not get that position. Hooters did go to court and claim BFOQ that their brand is all about the Hooters girls wearing the orange shorts and the tight t-shirts, in which a man cannot do. Hooters won. So that's an example of a BFOQ. You can also have a bona fide seniority system. This is more prevalent in the government arena. So if you have a explicit, probably written seniority system that says when you reach 2 years, no matter what race, color, national origin, gender you will receive X. At 5 years, you receive X. At 10 years, X. So that is a bona fide, a bona fide seniority system. And then finally, affirmative action plans. You guys probably are aware affirmative action plans are designed to close the gap in employment with different demographics. So basically, does your outside environment closely match your inside working environment? So thinking about Atlanta, where I live, in the city proper of Atlanta, the majority African American, and next is Hispanic and Caucasian. I think they're pretty equal. So inside, you'd be looking, is that what our workforce looks like? And if there's gaps, then what do we do about that? Well, we outline those in the affirmative action plans, and we do that once a year and set goals and things of that nature. We must, if we're a federal contractor, and now most companies do it as a just a means of a best practice. And so if we are recruiting, let's say, Asians and African Americans because we have gaps of that demographic inside our workforce, then that is an exception to Title VII. So those four. So make sure you're aware of those. And that was found on slide 20. Okay. So remember, I'm just hitting the highlights. Just because I'm not talking about it doesn't mean that you're not responsible and it won't be on the test. So the Civil Rights Act of 91, just put Teeth Act in the Civil Rights Act of 64. It allowed jury trials and it allowed compensatory damages. So in other words, it put teeth in the 64 legislation allowing for money. And so that's what 1991 did. The Age Discrimination in Employment Act, basically we're not going to discriminate anybody over 40. We're not going to make mandatory retirement based on age unless it's a BFOQ. Like, for example, let's say pilots have to retire by age XYZ because, we want our pilots sharp and we want them to be able to see. And we wouldn't want to limit employee status due to age. So, for example, you can't be a VP if you're over 65, something like that. Of course, another exception to the ADEA is, do we have a seniority system? We've disciplined or we fired you for a good cause. That's always a good defense. No matter what your age, what your race, what your color, we could fire you if it's for a good cause. And the employee is a top executive or policymaker. So those are the three. The next one I want to speak about is the ADA, the Americans with Disabilities Act. It does cover employers with 15 or more employees. This is found on slide 30. This was passed under Clinton's legislation, and it was designed to increase the employment rate with those with disabilities, because historically, individuals with disabilities have some of the highest, or probably the highest, unemployment rate. So basically, the ADA says we're not going to discriminate against qualified individuals with disabilities. Requires reasonable accommodation unless the employer can show undue hardship. We'll talk about that in a moment. And again, I talked about over 15 employees. And so this is where the concept of essential functions of the job becomes very important, and where job descriptions become important, because if there's ever a question regarding is this person qualified to be able to carry out the essential functions of this job, the first thing that somebody would look at would be the job description. And that's why it's incredibly important that our job descriptions have our essential functions listed. Um, there was also an amendment to the ADA in '08, which basically broadened the definition of disability. And it also listed the major life activities such as breathing, walking. If you're impaired that way, it's a disability. All those details are in your reading material, but I wanted to bring attention to that. Before we leave ADA, I'd like to talk about this concept of reasonable accommodation, because sometimes that gets a little confusing. So basically, let's say you're not blind, but you have issues with your sight. You need a computer that has big type. So you're interviewing at the Coca-Cola company. You make them aware of your disability, and you request to work with a computer with a large screen. So that would be a reasonable accommodation for the Coca-Cola company because they have millions and trillions of dollars. So let's say you were interviewing for a job in a small startup. That cost may really be an undue hardship for that company depending on its financial situation. So it's about reasonable accommodation and can the company afford it without an undue hardship. And so the chart on page 34 I like. Identifying a reasonable accommodations, the steps that you go through, those 5 different steps. So I would review those and make sure that you understand those as well. We talked about sexual harassment, the 2 types of sexual harassment. So you're familiar with that. Now, the cases mentioned in the reading and in the slides, they do a good job of summarizing those. There's also a listing of those in the resources area on learnhrm.com. And so I would review those as well, making sure that you know at a high level what those cases were about and why they're landmark. The next piece of legislation we're going to spend some time on is FLSA. In the past, sometimes this gives a little bit of anxiety for some students because it really governs a lot of what we do on a daily basis within HR, and it's got some pretty difficult subjects in it. So, it talks about minimum wage, overtime pay, who can work at what age, so employing youth, record keeping, full-time versus part-time, independent contractors, exempt versus non-exempt, which is a hot topic right now. If you're going to see litigation, right now it's in the area of exempt versus non-exempt, and they're doing it in a class action kind of way, like you probably heard with the Walmart supervisors. They got together saying, you know what, we may be called supervisor, but we're really non-exempt because we're really doing cashier work for the majority of our day and we don't get overtime. And so the EEOC agreed, and they were liable. And so first of all, let's talk about the independent contractor test, and that's on page 44. So thinking about independent contractors, here's my simple rule of thumb. If they look and smell like an employee, they are an employee. The piece of legislation behind this was, not behind it, but in support of this concept was with Microsoft. They employ a lot of engineers. That's what they do. Some of them were 1099s. Others were true Microsoft employees, but they both carried cards. They both used the same computers. They both went to trainings. They both reported to the same supervisors. They all had the same hours. So they looked and smelled like employees, and so the EEOC agreed and had to, back pay them because of the loss of benefits that they could have earned if they had been employees. The real test, besides the smell test, is who has behavioral control. If the company has behavioral control, then that's an employee. If you, the independent contractor, set your hours, you can do your own work plans, then you're in control, and that would make you a 1099. Financial control. In other words, do you, the employee, can you contract out to different companies, or are you tied to one? Can you show a profit and loss? If so, then you're probably a true 1099. And then what is the relationship of the parties? What is the contractual relationship with the parties? So those are three areas that the IRS will look at. And so employers have to be really, really careful around this because employers have the impression that it is cheaper, to employ 1099s because we don't have benefit issues, we don't have overtime issues, but in the long run, it could cost you if you misclassify. Okay, so let's look at exempt, non-exempt. Okay, so exempt means you're exempt from overtime pay, and it's typically our managers, leadership are in exempt level positions. Non-exempt means you are not excluded from minimum wage requirements and are entitled to overtime. Overtime is guaranteed to employees who are paid less than $23,660 per year or $455 a week. So that's the threshold. And so, looking at an exempt employee, page 46, they have to meet the minimum requirement. They're paid on a salary basis without improper deductions. We're not going to deduct 1 and 2 hours at a time because that would be improper for an exempt level employee. And their primary duties, remember we talked about essential functions of the job with the ADA, their primary duties are exempt. So back to my Walmart example, if we have a supervisor and their primary duty is to provide relief for other cashiers, that's not exempt level, that's non-exempt level. That's a working supervisor. So you have to get that title. You can't judge a book by its title, right? So you have to dig deep into the actual task of the job. And if it's about managing people, creating reports, hiring people, things of that nature, making major decisions about people in the business, then that would be exempt. So if you look on that slide 46 on the right-hand side, the primary duty is the main or most important duty. No particular percentage is in the FSLA. So in other words, you can't say, well, 50% of the time he's doing exempt stuff, and so that makes them exempt. Every time I've done this, I like to err on the side of caution because I don't want to have to pay back overtime because they take the employee's word instead of the company's if timesheets don't exist. So, I like to see 55, 60% of the job with exempt level duties. Okay, so that's exempt versus non-exempt. Now, how do you tell if it's an exempt position or a non-exempt position? So there's 5 tests. Executive, you can fall in the executive. You can fall in administrative. Think about your executive assistant to the president. She would be exempt, but not the payroll assistant. That would be non-exempt. Your professional, your computer, and your outside sales. So all 5 of these are found in your book. So I want you to make sure that you understand how those exemptions, you look at the exemption. Let's take outside sales, for example. This one came about because we were making telemarketers exempt when they really weren't. They were sitting there just taking orders via a script. And just because they had sales in their names, they were exempt, and companies were working them, 60, 70 hours a week and paying them on a salary. So what outside sales is, you spend your primary day outside the office working on sales. And so if you do that, then you would meet the outside sales exemption. So look up those 5 in your reading and make sure those are crystal clear. If not, please post a question in the forum this week and I'll be sure to answer that. But those are the 5 exemptions. And let's say you do make improper deductions to your exempt staff. For example, a manager that is exempt was 2 hours late and you dock his pay. That's an improper deduction. And so you have to, you'll lose your exemption if you keep this practice up. In other words, now your managers are going to be paid as if they're non-exempt, and that would be really expensive. And so you'll get a safe harbor if you have a policy that says we don't do this, if you reimburse your employees, and you say you won't do it again. So you get a little hall pass. And that was on slide 48. So the next topic, the FLSA, is definitely a large piece of legislation, and it really governs a lot of what we do. So it also talks about overtime pay. It sets the federal level of overtime pay at anything over 40 hours. Now, as you as a company, can you say 38 hours? Absolutely, but you can't say 42. You have to be at what the federal regs say or below. It requires overtime on time worked, not time compensated. I'm reading from page 50. So what that means is you have to physically have yourself in a chair working for 40 hours. You can't use sick time, holiday time, jury time, anything like that. You have to physically be in your seat for over 40 hours. And then it sets the work week of any 168 consecutive hours, 7 days a week, times 24 hours, Saturday to Sunday, or whatever the stretch is. You can set your work week. That's up to the company. The next issue that you sometimes get, a lot of companies have a best practice around that. It might not be the right practice, but comp time. Comp time is okay in the public sector and the government sector for obvious reasons. They don't want to use tax dollars to pay overtime, so they give a lot of their employees comp time. Overtime in the private sector needs to be paid in cash. So it's not allowed for private sector non-exempt employees. So if you're doing that, if I were you, I would correct that practice, because it's only available to our public employees. Slide 52, it talks about some other FLSA provisions, and the next slide talks about when overtime is allowed and when it is not. It's talking about on-call time, prep time, waiting time, meals and breaks, travel time, and training time. I want you to go through these and make sure that you understand when these apply, because that's definitely very important. If you have any questions, again, feel free to post it in this week's forum and we can discuss it, or we can discuss it in our next chat or WebEx meeting as well. But those examples I think are pretty clear and ones that you need to be aware of. Our Equal Pay Act, equal pay for equal work. I mean, that's as simple as it gets. If you have same skills, this is page 55, same skills, same effort, same responsibility, same working conditions, males and females should be paid the same. ERISA, huge piece of legislation that establishes minimum standards for our benefits and pension plans. In other words, it's protecting our employees in regards to pensions and what companies have to do to protect those pensions. The Pension Benefit Guarantee, the PBGC, was set up under ERISA to make sure that our pensions are protected, much like the banking industry has the protection for our money. This is it for the pensions. Also, it has rules about how we invest money in these pension offerings. It's a reasonable person standard. So there's all kinds of standards set up in that piece of legislation. Fiduciary responsibilities, who's eligible, vesting, talks about different vesting schedules, the communication to your employees, and all the different reporting. Let's see what else we have. Let's go into FMLA, because there seems to be some confusion around FMLA. So it covers private employers that have 50 or more employees for 20 or more work weeks in a current year. Employees must have worked at least 12 months, 1,250 hours, and it provides 12 weeks of unpaid leave, and that's for the birth, adoption, serious health condition of a child, spouse, parent, or the employee itself. And so I think where some employees get confused is this is unpaid leave. And so in the updated regulations, it talked about the intermittent leave. You could take it in increments of hours, which kind of was difficult to track. Medical certification, if you're fit for duty, how you continue your benefits, how you can do modified duty, and what was considered a serious health condition. And then the expansion later on expanded it to military personnel and their families as well. And so that is FMLA. The next is definitely OSHA. Um, it covers all workers in the country with just a few exceptions. It's um, it's enforced by the Occupational Safety and Health Administration, and it's just basically to keep our employees safe and healthy while on the job. And so, many of you that have um, worked in corporations or factories know that there's many different reporting requirements when someone is injured on the job. They do a good job of listing that in the book. There's posters that have to be published for employees. We have to correct violations in keeping our employees safe. On slide 70, that's a great slide about how do we keep our employees informed, how do we keep employees safe. And so OSHA is one of those pieces of legislation that you think, okay, what was going on? This was, I believe, it doesn't say here, I think it was in the 40s or 50s. So we had a lot of individuals in factory situations, perhaps some unsafe conditions. So OSHA was created, and this is one piece of legislation that has the data to say, it has helped working environments, and accidents have gone down, and work-related illness has gone down as well. So let's see what else we need to cover. Why don't we talk about, not too many left. Let's talk about National Labor Relations Acts. In other words, those acts that impact unions. So we all probably are aware unions have a decreasing membership as of recent history. Before more common in the Northeast, where most of our factories in automobile and textiles and things like that. On page 75, it talks about the NLRA, the Labor Management Relations Act, and the Labor Management Reporting Disclosure Act. And basically, starting from the top on page 75, the NLRA established workers' right to organize and bargain. So it gave workers the right to bargain and join a union. And then next, the LMRA amended the NLRA and imposed several restrictions and requirements on unions. So the first one, National Labor Relations Act, gave more power to the union so they can organize easier. And then the next one kind of pulled it back and put some more standards and requirements on them. And then the last one, the Labor Management Reporting Disclosure Act, it amended the NLA further and imposed regulations on internal union affairs and the relationship between union officials and union members. So again, putting some more infrastructure in place for unions. And you can read on that some more in your book and on the next couple of slides. So I think that's the highlights. There's some other laws in here. Obviously, I didn't want to make a video that was 8 hours long. I'm sure I would have lost your attention span by then. Look at the EEOC complaint process. I think that's a good one to understand, when a complaint is filed and then what happens after that. And then it ends with records management and things of that nature. And so, again, I think it's important to think about the context of these laws, who it covers, minimum number of employees and things of that nature. And I think the information that you have here in your slides, also in your book, and online are really going to prepare you for this. And again, questions after you've read your material, please feel free to post them in this week's forum and ask the question, because if you have the question, I'm sure somebody else does. Thank you for your attention, and I'll talk to you very soon.